Hello, welcome everyone to today's ILTA podcast titled Cyber Threats, Latest Trends in Avoiding Attacks, Part 2. I'm your moderator, Ray Jones. I'm a cybersecurity analyst level 2, and I'm thrilled to be joined today by Mike Kelly, CEO of ProcessBolt, on the second installment of this ILTACON Encore session. Mike, would you be so kind to give us a brief introduction?
Absolutely. Thanks, Ray. Again, my name is Mike Kelly. I'm the CEO at ProcessBolt, which is a third-party vendor risk software platform. But prior to that, I think relatively important for this group, I was a partner at the law firm of what's now called Faegre Drinker. Back in the day I was there, it was called Faegre and Benson. And I served on our technology committee, so was involved in onboarding new technologies. And after leaving Faegre, I have started and sold a couple of software businesses. And currently, last few years, I've been running ProcessBolt and have gained a lot of experience in working in cybersecurity areas with law firms.
Awesome. Okay, Mike, feel free to continue with the
Great.
session.
Thanks, Ray. All right, so today we're going to kind of look at current trends, and then at the end we'll talk about best practices, primarily in third-party risk dealing with law firms. So I'm going to start and talk about the fact that, and probably many of you who are watching this already know, we're seeing a dramatic increase in the number of attacks against law firms. If you look at the breach statistics, 40% of law firms with 100 employees or so have experienced breaches. And there were 21 firms reported breaches last year in 2024. Actually, need to update that, I believe. But it shows a rising attack in law firms. And what's happening is, hackers are generally going to look for the weakest deer in the herd, right? They want to look for the businesses that have the most valuable data and the businesses that have the least least experienced or really well-developed cyber infrastructure. And because the law firms have all this valuable information, whether it's trade secrets, whether it's M&A information, whether it's PII, there's plenty of bait there for those hackers to go after. And what we're seeing is not only an increase in attacks, but we're seeing a real rapid increase in the damages that law firms suffer from once they see these breaches. In the last couple of years, we've seen a dramatic increase in class actions. And I'm going to talk about that in a little more detail later in the talk. But what's driving that really is now there's an expectation, and there's regulations, ABA guidance and regulations across many, many industries that are requiring more robust third-party vendor risk management practices and, plans in the event, remediation plans in the event those protections are inadequate. And when you look at vulnerabilities, we've seen that only 29% of firms have undergone security assessments. That is going to dramatically increase. And 42% have incident response plans. So there's really a lot of gaps still there that law firms really need to protect against. And this is when you talk to your technology committees, these are really important statistics to have. Along with these, when you look at the cost of a really robust, complete, comprehensive management program, it is absolutely marginal, minuscule compared to the cost of addressing just one breach. Third-party risk accounts for roughly 60% of the breaches that you see today, you read about today. We're going to talk a little bit more about that too. The average cost per incident to address those breaches is about $4.5 million, but it's significantly larger, closer to double that for law firms. And we'll talk again a little bit more about why that is. So what are the damages? Well, there's always the detection and escalation category of damages, 1.2 million. These are all averages that I've taken when we've come in after breaches for some of our new customers. 270,000 for notification. Obviously, that's contingent on the number of individuals affected by the breach. 1.14 million in post-breach response. These are the mitigation plans we talked about. And 1.85, and this is a tough estimation here, but we've kind of pieced this together too, for brand damage and lost business. What this doesn't account for is the class action settlements that we're now seeing coming out of these. So you have your incident response damages, your breach damages, but now you're seeing class action settlements in the millions of dollars, because having a robust vendor risk management program is really required at this point, because we're finding that it's gotten to the point where there's enough evidence that it is negligent if you don't have such a program, that the class action lawyers are flooding into this area and getting very attractive settlements from law firms who are inadequately protected in this respect. So let's look at a couple of these breaches. These are a few of the ones that you may have read about recently. Orrick Harrington was suffered from the Move It breach. Now, a lot of you have read about this file transfer, and I don't know enough about the details here, but the fact that they agreed to pay $8 million in a class action settlement means that most likely there was a significant delay in responding to this breach. The Move It breach, I'm sure all of you in the security profession know about. It was a 0-day breach. So you may not have known about it before it happened, but it was communicated. And at that point, you have an obligation, obviously, to do everything you can to try to mitigate it. What we were able to do at ProcessBolt was we were able to notify our customers of the vendors that most likely were using this file transfer method. So whether it's through your third-party vendor, your vendor risk management vendor, or through just notice from the Move It folks, you need to react quickly to these breaches. And obviously there's an issue there at Orrick Harrington. The Gibson-Dunn breach, you may also know, was caused by a vulnerability in the Citrix system, which allowed unauthorized access to patient data. Again, total cost of the breach we don't know about, but we do know they paid $2.125 million to the SEC, which meant there was something there that they were concerned about relative to responsibility. And the Citrix system is a really good example. In another talk I gave, we talked about the 5 leading indicators of poor cyber hygiene. And one of them is just making sure you've institutionalized the practice of updating your software and patching it regularly and quickly. It's really surprising to us when we look at the vendors of our customers with our continuous monitoring component, or even the assessment component, how often we see unpatched software or deprecated software that is still being run. TLS 1.0, for example, we still see all the time. Any event, a critical piece of your cybersecurity hygiene must be a program to make sure you implement patches right away, you retire deprecated software and update. The final one is the Kirkland and Ellis breach, where they are facing a class action, and I haven't updated this. It may be that that's been resolved too at this point in time. But despite the firm's privacy policy assurances, Kirkland didn't notify the client until months after, and obviously some consumers were only informed nearly a year after the breach. This is another thing. You need to make sure that your actions are consistent with your published policies, because if you get into a class action, you're going to be cross-examined on those published policies. You better make sure that your practices are consistent. Those are just a few of the breaches you've seen recently. We're looking, when I talked about kind of the leading indicators of poor hygiene, these are some of the really basic things that a law firm must have as part of their best practices. Okay, 42% of the law firms use outdated software, which exposes them to security flaws. I just spoke about that. Make sure you update your systems and you patch regularly. Only 58% provide employee training. Only 58%. This is also a critical component of your overall cybersecurity hygiene. You must have a program implemented to update your employees on these evolving threat vectors. And 35% of firms lack any sort of formal vendor risk management program, which at this point, I guess I should say I'm shocked, but I'm never shocked. We had a publicly traded company, which I still can't believe had no vendor risk management program in place. And it happens. And I think a lot of times there's this belief that it is expensive or complicated to have a comprehensive vendor risk management program, that simply isn't true. There are some great products and services out there that are available at relatively modest cost. As a matter of fact, we offer a completely outsourced managed service for vendor risk management, and there are a number of other players in the space that do something similar. So it's not expensive and it's not complicated. And even if you don't have the staff to man it, you can do it on an outsourced basis. And it's critically important to protect your organization. 77% of the law firms do not use two-factor authentication. And now beyond two-factor authentication, there are authenticator apps. And earlier, I gave an earlier talk with John Washburn and others about, and he gave a presentation on MFA bypass. Yes, there are techniques out there to get around multi-factor authentication. Authenticator apps are probably leaving a little more safe, but nonetheless, at least have the MFA in place. So consequences, I talked about this. I'm not going to go over the financial losses again, but there's also reputational damage, which is really critically important. When your law firm gets assessed by a new customer, they're going to know whether you've been breached, and it's going to create issues for you. You're going to have to explain that. So protect yourself ahead of time, and don't worry about suffering this reputational damage. Don't be on my screen of one of the 3 most recent breaches. Those 3 law firms are sophisticated law firms. Those are not resource-constrained law firms. So any business can be targeted, and you need to protect yourself, and it's not costly or expensive. There are legal and ethical implications in addition to the reputational damage and the financial damages that are directly related to a breach. And I'm going to discuss that a little bit more, but the lawyers in your firm are obligated professionally under the ABA model rule of professional conduct to safeguard your client data. I'm going to talk about that more. Class actions are at a record level and only climbing, and that's because it is now considered practical negligence per se if you don't have a program in place. You must have something in place. And obviously, there's significant long-term damage as well. So let's talk about the professional rule, because this is really specific to your law firms and your practice area. And I think this is important to talk about when you go into your technology committee looking for budget for your program. These are things that are really important. Under Model Rule 1.6c, lawyers are required to make reasonable efforts to prevent authorized access to client information, which directly relates to protecting sensitive customer data. This means that you must have security measures, including encryption, secure communications, access controls to protect your client data. And the model rule also now requires the use of protections against data security leaks, such as the risk of third-party vendors and vulnerabilities within those third-party vendors. So you need to implement appropriate measures to safeguard against those risks. So third-party risk management is absolutely critical in law firms and is really spelled out in the ABA's model rule of professional conduct. And finally, you need to have an incident response plan in place too. But what you're seeing here is that, and I'm going to talk about this more, whether it's this model rule of professional conduct, whether it's the EU DORA Act I'm going to talk about, or some of the other regulatory frameworks at CMCC, if any of your law firm's customers are doing business with the defense industry, there's a convergence of regulatory guidance that is requiring fairly comprehensive third-party risk measures because it is such a sensitive area. Virtually all of these regulatory structures require not just the assessment of your supply chain and your vendors, but also the continuous ongoing monitor of those vendors, as well as having an incident response plan. So let's take a look at some of these regulations, because we are seeing this convergence, as you say, of various regulatory frameworks requiring a higher level of vendor risk management. In the US frameworks, many of you are now aware of the CCPA and the state of New York's equivalent. This is not necessarily new, but it is a regulatory framework that requires not only privacy protections, but security protections. The DORA Act, or Digital Operational Resilience Act, you may not be familiar with. This just went into effect this year in the EU. It pertains just to financial industries and financial services industries, but I know many multinational law firms have customers in this area, and you need to be aware of it. And I'll talk a little bit about more what the DORA requires, but among those other things, it is a robust Cybersecurity Protection Act. Okay, what the Digital Operational Resilience Act requires in Chapter 5 requires not only third-party risk, but it requires a third-party risk program, an assessment program, but it also requires a continuous monitoring of all your vendors for any sort of evolving threats. And this is really important because what we see and what's important in our work is a rapidly evolving threat landscape. And to think that you can rely on a once-a-year assessment to gauge the security of your supply chain is foolishness at this point. Anything can happen once that assessment is received, and oftentimes those assessments only involve the attestation of someone at that organization. You must have continuous monitoring as a component of your third-party risk management program, and that's essentially what DORA is requiring. So again, we're seeing another regulation that's moving us towards a really complete and complex requirement for third-party risk management. All right, the next thing I want to talk about before I kind of wrap this up is AI regulation. Whoever you're using for third-party risk, or whether you're doing it internally, there ought to be an assessment process in place for AI. We've seen in the EU the passage of an AI regulation that is trying to get to a uniform, comprehensive regulatory framework for AI. And it bases it kind of on a tiering basis, or looking at risk-based regulation and tiering the level of assessment you need to have based on the criticality of those frameworks. And we've seen a movement that way in the US, but it's been on a state-by-state basis. 45 roughly states right now we've seen have some sort of AI regulatory framework in place. But what we do know is, again, whoever you're using for your third-party vendor risk, or whether you're doing it yourself, you ought to be assessing your vendors for their use of AI, because it can create vulnerability for you as well. So let's look at just a couple of these pieces. So you want to make sure that you establish, clear guidelines on how AI can be used. All these things you can assess your vendors on very easily using whatever your third-party risk platform. If they don't allow you to assess AI, you shouldn't be using them. You need to be able to review what they're using for governance in AI, how they're evaluating their models, what data they're using to inform their models, what they're doing to prevent hallucinations, and how are they assessing data privacy and security within those. You need to look at whether they monitor for algorithmic bias, which is a critical issue within any sort of AI framework. You need to continuously monitor it because the AI is continually evolving. So it needs to be continuously monitored, and there needs to be an incident response plan in place in event there's a failure or breach in the guidelines that you have. So assessing for AI risk is as critical now as other third-party risk. So I thought I would call this out because we saw this. One of our customers, obviously, is a very large Fortune 100 retailer. And I'm guessing that many of you law firms, if you're not dealing with a Fortune 100 retailer, would like to be dealing with this Fortune 100 retailer. But what they're saying is, if you're going to do business, any business with this retailer, you're required to sign this, where you have a vendor risk management process in place that includes a security assessment, remediation of findings, and ongoing monitoring of companies' vendors. So if you don't have these three components, what I've been talking about through this whole talk, you will not be doing business with this particular vendor. You can look at regulatory guidance that's pushing you this way. You can look at large corporations that are pushing you this way. But you're going to be pushed, and your technology committee and your leadership at your law firm need to know this. If you don't have a vendor risk management program that includes security assessments, remediation of findings, and ongoing monitoring, you're going to run into issues. You're going to lose business, and you're going to subject your own organization to risk, critical risk. To wrap up, and I can talk about that too, there's this raging debate now whether security assessments are even necessary if you have continuous monitoring. I will say resoundingly, you need both. Continuous monitoring, unless you're doing a pen test, can only look at the surface, can only look at the internet-facing attack surfaces. It cannot look at your overall cyber hygiene. The security assessment, while not sufficient in itself, is still a critical component of good cyber hygiene. So let's look at this. Just to summarize, we talk about making sure you have MFA, making sure you conduct regular audits, make sure that you have cybersecurity training protocols in place, make sure that you have a good program for continuously monitoring your vendors, and be proactive in it. Ideally, you would have many of these things in an integrated process or an integrated platform. And finally, to wrap up, I wanted to just pull up this one slide, which is an example of best practices culled from a number of our customers and put together by a leadership committee among our customers. And this is what they do. When a vendor comes in, is requested, you look at all the potential sources for that vendor coming in, whether it's HR, whether it's supply chain, revenue management, if you're healthcare, marketing, the law firm could come in from any number of sources, someone who wants to use a software product. You need to make sure you have an inventory of all those technology assets that are coming into your law firm. Once that's done, the next step is to review all those technology products, anything that's touching data, anything that's exchanging data, and set up a hierarchy. We usually call it tiers of criticality. And based on those tiers, you go on to the next step, which is risk assessment. In some cases, something very simple like a SIG light might be required. Even lighter might just be collecting a SOC 2. But your more critical vendors, you're going to want to do a comprehensive assessment, whether it's a NIST or ISO or HECVAT, or build your own assessment, which most of our customers do, which is some sort of hybrid of all those. Then you run that assessment. You also run your continuous monitoring over their internet-facing attack surfaces and review their policy, enter the information in your risk register, and then set up your response program. At that point, your step should be look at all of those points, their internet-facing attack surfaces, their assessment, and their policy. Hopefully, you'll have a tool, this is my one plug, that can do all those things. And then you can remediate based on those. Once that happens, and all of your vendors have reached the level that you set for their standards to do business with your law firm, you move on to the phase on the right side of the red line, which is tracking the remediation, make sure they have become compliant, and then continuously monitor them. Finally, based on where they fall in their level of criticality, you reassess, typically on an annual basis, but you continuously monitor those that are most critical. And this is the best practices that we see among our customers. And that's what I wanted to share with you today. And I can turn it back to you, Ray, but I hope it's been helpful. I think I might have one more slide that has contact information for Ray and for me. And if you have any questions on this stuff, or you're going through this evolution with your law firm, please don't hesitate to reach out. We talk to a lot of people, whether they're existing customers, prospects, or just trying to get information. All of our goal in this industry is to make sure that everyone gets protected so that the hackers don't win at the end of the day. Ray?
That's the goal. Thank you so much, Mike. Very informative session for sharing with us everything about data breaches and preventative measures and different strategies to prevent that from happening. So we really appreciate you joining us today for another ILTACON or Encore session podcast. If you haven't already had a chance to check out part 1, we highly recommend giving it a listen, and don't forget to stay tuned. There's even more exciting security and compliance content coming your way this quarter. Again, thank you for joining us, Mike, and thank you all for listening. We'll see y'all next time. Take care.
Thanks, Ray. Take care. Bye-bye.
Bye.